will be addressing the media and making statements about the case until after the trial. We won't be answering any questions here today. We won't be discussing any facts of the case. Our clients, we've spoken to them about this. They're behind this. They understand our need to getting our side out. Last week, our clients, Mr. and Mrs. West, were arraigned on an indictment of 5 counts, including second-degree murder, and that came as a result of a grand jury convene. There's been great confusion we've seen about the difference here between a grand jury and a trial jury, and the two of those things cannot be more different. First, the standard of proof is lower for a grand jury. They need to only determine probable cause, which is one of the lowest legal standards our system holds. They also do not require a unanimous vote by the jurors. The prosecution also has broad discretion in determining how to proceed and doing so by way of indictment. The grand jury process lacks a crucial and important role of our criminal justice system, and that is the accused and their counsel being present during. There's no opportunity to cross-examine any witnesses, and it is basically ran by the district attorney. This is to the detriment of the accused, as evidence of a speculative nature has a way of integrating itself into this most secretive of all legal proceedings. On the other hand, a trial by jury, they must unanimously agree on the issue of guilt or not guilty. And there you have the highest standard of proof, which is beyond a reasonable doubt, and it is a proceeding done in open court. The state's comment and reliance on this "we have proved to a grand jury" is mere rhetoric. It's used as an insurance to bolster a lopsided indictment. Comments such as this have no place in an actual court of law, where it is 12 individuals who unanimously decide the outcome of this case based on this highest level of burden of proof, which is beyond a reasonable doubt. Statements that have been used by the Kern County District Attorney in her press conference tend to invoke a tidal wave of emotion towards finding guilt, whether substantiated or not, and this will taint a local jury pool and could deny our clients a chance at a fair trial. It's odd that the office held their press conference, made a series of comments which both mis- and disinformed the public, then the following day came and requested a gag order to stop the defense from having an ability to make similar comments. This action is disingenuous, but may also cause change for a change of venue in the future. This is an election year, and this case is serving as a compass to guide the DA to her path of re-election. However, it is now when the misleads in theater end and the constitutional protections begin. The safeguards of the accused and the fight to preserve those for Trezell and Jacqueline West begin now. And I thank you.
And you guys are requesting a change of venue.
I think that's something we have to discuss further and see where we're at. I think the concern is that that is where we end up, and we'd like to avoid that if we could. It should stay in Kern County. It's Kern County's people. So, but that being said, I think it's something that we are aware of and paying attention to.
In establishing sort of like the timeline that you guys are going to be working with here, and speaking to your clients as well, were you guys able to establish when exactly the West moved to California City?
I think that that's a little bit beyond the realm that we would like to discuss here today. We definitely do not mind talking procedure, but that's a little bit over what we wanted to discuss. Thank you.
You guys also said that there was some stuff that Ms. Zimmer said at a press conference that was like a little emotional, tugging at those strings. Could you talk specifically what were the stuff that she said that really struck you as bad?
It's not to say that this is not going to be an emotional case. However, we did believe that there was some phrasing that was used that to a lay person implicates one thing, but to an attorney or to many attorneys implicates another. When we hear stuff like, we proved to the grand jury, they were convinced, they believed, that isn't the standard in which they make their finding. And so to us, it was to more clarify that that isn't the standard. That isn't to say that the grand jury aren't humans and that they obviously can't make up their own mind. It's just that that's not the same standard in which we know the standard to be.
And then one last question, just more of like if a person isn't a lawyer, a gag order, when is that implemented? What's sort of the standard that has to be met there for a judge to be like, yes, we're going to go forward with this?
I would say the request of a gag order is relatively routine in a high-profile case. I don't think there's anything out of the ordinary in requesting it. I think the only thing that didn't sit necessarily right with us was a press conference comes out and then they want to place a gag order. And I think to us it was like, well, we should also have our opportunity to address exactly what we've done here, how we see it differently.
Sure.
But other than that, not talking about the case, because the reason why then I think Alexia talked about this as kind of the essence here is we want jurors who are going to sit and hear the evidence, how it's supposed to be presented. Let this play out. I mean, this is one of the fundamental things our society has is trial by jury, and it needs to stay pure and be what it should be, and that be 12 unbiased jurors listening to the evidence, making a decision. The minute that starts to seep into the jury pool and things change, that's our concern. We just want to get it now. So that's why tomorrow we would agree with the gag order.
There is currently, also a lawsuit that the county has placed on the West for, are you guys sort of going to tackle that lawsuit as well? Are you guys going to represent them on that litigation as well? Or is that going to complicate this for you guys a little bit?
So the answer to that right now would be no. It was my understanding that the lawsuit, the civil lawsuit, is filed by the biological father.
There's another one. So the county, the West, are facing like a child support lawsuit, I believe, for the other children.
Okay.
So there's the biological one, but then there's also the one by the county.
And you're not referring to a dependency issue?
It is the dependency one.
Okay. Then in that case, we do not represent them in that particular matter. They actually have other attorneys who have also been court-appointed through the Indigent Defense Program who represent them in that matter. That is not to say that we aren't working together. It's just that we aren't representing them on that matter.
It assigned us. I mean, we were available for appointment.
It did, but I will note that we are asked if we would like to take on a case, specifically Mr. Hennessy and I, and we did choose to take this on.
Sorry, just to go back again to the change of venue question, you guys did say you guys have to discuss it a little bit further as well. But what would it depend on to motivate you guys to ask for a change of venue?
There are specific factors that we have to look into, that we actually have to do research on before we could bring that motion to court. As an officer of the court, we are bound from bringing frivolous motions, and so we want to ensure that there is at least some basis for that. I will point out that as you all have been covering this case, I too have been reading everything that you folks have been producing. But specifically, I would direct you to that Robert Mistrial case. I did read an article several years ago that indicated that I guess at the time of the hearing that the court was able to establish that 72 to 79% of the county either were aware of the case, had an opinion about that case, etc. Again, these are motions that are not granted often, and so a lot of times attorneys have to go back to the cases before us to determine how something can be brought about.
I would think the sentiment from both of us is as pleasant as this has been. We'd rather not be doing this. We'd rather not be thinking about a change of venue. We'd rather just getting ready for a case, going before a jury and trying it. I think that would be our preference. I think in this one instance, because of the unique circumstances that got us here, we wanted to make this statement to point some things out before kind of shutting it down and doing it at trial like it should be done.
Anything else?
Thank you.
Okay, thank you.
First, before we start.